The First District Court of Appeals is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. Good afternoon.
Good afternoon.
Good afternoon, everyone. We have one case on the docket today. It's case 19-4017. I see that counsel for both sides are present. So counsel for the appellant, you may proceed when you're ready.
Judge Ray, before we get started, I did want to give the court a Thanksgiving gift, which is that I am planning on my esteemed and eloquent co-counsel, Mr. Hurto, who is appearing pro hac vice to make the argument. The clerk advised that this is unusual to have someone just sitting here, but I figured that if we were doing it live, I'd be sitting at the table with him and that it would be okay. So thank you, Judge.
Okay, so noted. So we'll turn it over to Mr. Hurto. Did I pronounce that correctly?
Yeah, it's Hurto. There's actually debate in our family how to pronounce it, so we'll go with Hurto.
Okay, I apologize for mispronouncing it, but you may proceed when you're ready.
No, that's fine, and thank you all. And if it may please the court, I am here to represent the appellant, Jeffrey Amin, who is the guardian for his two children, for Jade and Asia Amin. In this case, the judge below, Judge Deering, and the appellee both are relying on an argument that a proposed settlement or a settlement proposal that was entered into between some brothers and sisters back in June of 2009 is sort of the point in time that we need to look at to determine whether or not the mother of the two children that I represent could, through her power of appointment, somehow bind her children to a decision related to that settlement. And we are going to argue.
Mr. Hurto,
yes,
isn't kind of the key issue we got to figure out here today is whether Jade and Asia had any kind of beneficial interest under the trust to start with?
I mean, that certainly is an issue here, is whether or not they had an interest, if they were a beneficiary. I mean, it's our position that they did have an interest. The moment they were born, they had an interest. And that interest certainly was there in June of 2009, because at that moment, they were the only two issue of Kirsten and my client, Mr. Amin. And under the terms of the trust, they at that moment, at the very least, were qualified beneficiaries. So it's our position that they certainly had an interest, and the mother, could in the future have changed that interest. Primarily, she could have changed it as between her two daughters, or if she had other children, that might have made a difference, and she might have been able to make a change.
Well, isn't it true that if they didn't have an interest that could be extinguished somehow by the actions of Kirsten, that they weren't really a beneficiary of the trust, and the settlement agreement could have done what it apparently did?
Yeah, I don't think that it could have done what it did, and I don't even know that it did anything at the particular time that they put it together, the settlement proposal. But, making the assumption, and I'm making this assumption, that they had some beneficial interest at the time in 2009, their mother could not give away their interest for several reasons. The first reason I'll give you is that she had a conflict. If you look at the statute 736-302, it indicates that she, having the power of appointment, can bind people that might take or might be beneficiaries, but she can't do so if she has a conflict. So at a very minimum, there's a conflict of interest. Sorry, Judge.
Let me stop you a second. I'm going to go back to something that Judge Roberts was talking about. You said that the two children are qualified beneficiaries. And I'm looking at that term under Florida Statute 736-013.
Yes.
And I was wondering if you could tell me how you see them as qualified beneficiaries, as that term is defined by that statute.
Well, I see it as qualified beneficiaries because they were the issue of Kirsten. Kirsten, under the trust, Kirsten's issue had a right in the particular trust. And again, she had the power of appointment, so she may have been able to make some changes within that. But once they were born, they were entitled to some benefit. And it's just a question of what that benefit might have been. So
looking at
in my reading, Mr. Hurto, of let's go to the trust and let's go to paragraph 2B. My reading is she could have certainly that she had the power to appoint them as people receiving under the trust, but she wasn't required to appoint either one of them, or could have appointed one and left the other one totally out. And so if one of the children, it looks like to me reading this, neither one of the children ever had a right to receive under this trust.
Your Honor, the way I read that trust is that either one or the other had a right, that the mother could not eliminate both of them.
Neither one of them had an enforceable right. Do you agree with me on that?
I agree that one or the other of them had an enforceable right, because the mother could not get rid of, she couldn't just say that neither of her children or none of her children got anything. At the moment that this settlement was entered into, she had 2 children. At that moment, one or the other, at the very least, had a right, and they were a beneficiary. She couldn't at that moment, let's say she gave away her ability to appoint, which is an argument that the other side is making, that's one of the things she gave away. If she gave away at that moment her right to appoint, then at that moment, her children become default beneficiaries, because one or the other of them were going to get whatever she had or whatever
is that necessarily true? Because theoretically, she could have had another child before she passed, and she could have appointed that child to receive everything, and neither one of these children had a right to receive in that circumstance.
Well, in that circumstance, that's right, but it depends on which theory we're looking at. If you're looking at the theory that at the moment in 2009, when that settlement agreement was put on that record, the settlement proposal was put on the record, if at that moment she gave away her interests, so she had 2 interests at that moment. One interest was that she had an interest in the income from the trust. The second interest she had was the power to appoint. If she gave that interest away, at that moment, her children then become the default beneficiaries. And so because they were alive, they existed, she gives away her power of appointment. And at that moment, they become default beneficiaries.
Well, how do you reconcile that with the power of appointment being testamentary in nature? And so she could only exercise it in theory at her death.
Well, again, our argument is this settlement proposal had no effect or impact whatsoever. And in fact, what happened in this case is that this settlement agreement, really settlement proposal, which is in and out of the courts all the way until 2015. While that's happening, these beneficiaries, these potential beneficiaries, default beneficiaries, whatever you want to call them, let's just call them beneficiaries, their mother dies. And when their mother dies, at that moment, they become current beneficiaries because their mother cannot and does not, she doesn't have a will, she dies without a will, and she doesn't make any power of appointment. So at that moment, they become current beneficiaries. And in fact, way back when the settlement agreement was proposed, and before it ever became validated and enforceable in 2015, no effort was made by the trustee to terminate this trust. The trust was never terminated. So whatever interest they had, there was no effort to terminate. And by the time an effort was made to terminate this trust, they were current beneficiaries. In fact, when their mother died, the trust documents that Judge Roberts was just referring to, they required that the trustee split the interest between the 2 or 3 or 4, however many beneficiaries exist, and they got different and more rights under that trust agreement once their mother passed. So, you know, our argument is she didn't have the power because of a conflict, number one. Number two, another important issue in this case is the fact that the father and the mother of these children were not married. You look at the settlement proposal, it talks about releases being given by spouses and children. It talks about that. Mr. Amin, when this settlement happened, and everybody at the table knew this, was divorced from Kirsten. And they had a divorce decree and they had a separation agreement. And that separation agreement specifically says that they are both the legal custodians and they're to share legal custody of their two children. And the separation agreement has a provision in it. If there's ever a dispute between the two of them about the legal interests of their daughters, there's a process of mediation they can go through to try to resolve that issue. So at the moment that she may have been trying to do something with her interest in this trust back in 2009, at the very least, there's an issue of fact as to whether or not she had a conflict. There's certainly an issue of fact as to whether the trustee had a conflict or if there was fraud or bad faith on his part. Because remember, the whole idea between this agreement in 2009 is you've got brothers and sisters fighting and they're dealing with their own issues. They're not taking care of their children. They're not thinking about the interests their children may have, however slight they might have been. I have to agree with you. Eventually, their rights could have been defeated by their mother, but they were not. So either she gave away that right and they became default beneficiaries so that when eventually the trust was terminated, then they had rights at that point because their mother had already died. Or, they continued to have rights going forward because the settlement, the 2009 settlement, had no impact and had no effect because it never became valid and enforceable until sometime after the mother in this case passed away. I mean, I hope I answered that question.
You did mine. Thank you.
Okay. Again, we've got these three issues of conflict. We have a potential issue here of bad faith and fraud. Both of those would have required that a jury or a finder of fact determine whether or not there was such a thing. At the moment in 2009 when this proposal was put together, or the same is true when the trust was terminated or allegedly was terminated by the trustee. In either event, there should be an analysis of the position of the trustee and even of the mother and whether or not she had a conflict of interest. The mother didn't have the right to give away anything from these children without getting permission from her former husband. They had an agreement to that effect that she could not do that. This settlement agreement, as I said, it had no impact or effect in 2009 because almost immediately after this proposal, and that is what it's called, was put together, the parties started suing each other. And there were several suits in New Jersey, Florida, and back to New Jersey before finally it was considered to be valid and enforceable. So, and I think I actually forgot to, I wanted to reserve 2 minutes. I don't know if I'm too late to do that, 2 or 3 minutes. I see my time's running down. That's what reminded me that I wanted to try to do that if I could. Okay. I don't know if I could do it late or not.
You may do that now.
Okay, thank you. I'll reserve my time.
Okay, thank you. Okay, counsel for the appellee, you may begin when you're ready.
Good afternoon. Harris Bonner for the appellee, Wade Shogren. May it please the court. As one point of a housekeeping matter, I have noticed that I'm having a bit of trouble with my internet connection, and I'm seeing that it is a bit unstable. It seems to clear up, but then go away. And so right now I'm seeing a frozen screen. So I may have a little bit of internet issue. Can you hear me okay?
We can hear you okay. The video does pause occasionally, but the audio is fine so far.
Very good, thank you. So may it please the court. There are several issues that I'd like to address with the court, but I'd like to kind of take a quick broad view first and just kind of make sure we're all on the same page on some of the basic facts, just briefly. And so if the court will recall, we have a husband and wife, Wade and Jane, who were living in New Jersey and had 5 children. They had 2 sons and 3 daughters, okay? And as time went on, the children grew into adults, and the father, Walter, died. And after his death, the mother, Jane, undertook some estate planning. And part of that estate planning was, among other things, to establish a trust, one each for each of her 5 children, and including their daughter, Kirsten. And that, of course, is the trust that we have at issue in this case. And under terms of that trust, as the court has already pointed out during Mr. Hurto's remarks, was that it provided that Kirsten had a testamentary power of appointment. And as the court acknowledges, Kirsten could exercise that power of appointment and appoint all of the assets to one child, all of the assets to the other child, or some blend between the two. And here's something else that's important. That class of permissible appointees did not close until Kirsten died. And so she could have had another child. And so that would have added yet one more individual into the class of permissible appointees. Okay. After Jane established these trusts and there was some activity going on, there became some disputes and some family disharmony, if the court will recall from our submissions. And ultimately, the 3 sisters filed a lawsuit against the 2 brothers and the mother, Jane, okay? And that litigation went on for some time. There was some discovery and whatnot. And ultimately, the parties reached a basis of settlement and memorialized their settlement in a written settlement agreement. And the terms of that settlement agreement were also read in open court. And there's a transcript of that open court proceeding in the record. And
Counsel, if I could intercede, Counsel,
and under that
Counsel,
settlement,
can you hear me?
The parties basically had a family divorce, and that is the 3 sisters got.
Counsel, can you hear me
Yes, Your
now?
Honor, I'm
Okay, so my question relates to.
I can hear you now, Your Honor.
Okay. My question relates to a point that appellant
it's
counsel
coming
made.
in now slowly.
Okay. He argues that it was a settlement proposal and not an enforceable and binding agreement in 2009. Would you respond to that?
And I only heard the last part of your question, but I think it was this an enforceable and binding agreement, Your Honor? And I submit, Your Honor, it was enforceable and binding agreement on June 23rd, 2009, when the parties read that into open court. Now, Your Honor, if I can just, in further response to your question, there were disputes about some of the terms of the agreement. And so ultimately, the 2 brothers, my client and his brother, asked the court to enforce the agreement. And the New Jersey court ultimately issued its order in 2014, determining that it was an enforceable settlement agreement. It was enforceable and binding as of June 23rd, 2009. And I'm getting a message that my internet connection is unstable, so I'm hoping you hear me. All the images are frozen.
Yeah,
So
we can still hear you.
Okay, good, thank you. And so, so when the New Jersey court issued its 2014 order, if Your Honor will recall, the judge, when he entered that order, said, look, this is a binding settlement agreement and it's enforceable, but it involves Florida trusts that are governed under Florida law. I'm not a Florida judge. I want you to go get an order from a Florida court saying that this agreement that says that they can either terminate or modify Kirsten's trust is not illegal under Florida law. And that is exactly what my client and his brother did. They initiated a lawsuit here in Florida and engaged me to initiate that lawsuit. And ultimately, the Duval County Circuit Judge, Judge Pete Deering, entered an order finding that indeed it was not illegal under Florida law for these terms of the settlement agreement affecting the Kirsten's trust. That is, either terminating it or modifying it. So once the New Jersey court received the Florida court's order, it then, the following year in 2016, issued a final order saying, this is enforceable. And now I am going to force it, and I'm going to put the full weight of the state of New Jersey behind this order and enforce it and order you to do all these things. And I think the New Jersey judge prior to that was a little unsure that he could put the full force of the state of New Jersey behind his order when it involved an issue over Florida law, involved interpretation of these provisions under Florida law. So that's why the judge said, go get me a Florida judge to say this, and then I'm going to enforce it, which is exactly what happened. But Your Honor, the settlement agreement that the parties entered into in 2009 was a meeting of the minds between all parties. They reached an agreement, they signed it, they read it in open court on the record, and it was binding. And the subsequent orders said, yes, this is binding. I think perhaps the appellant is making the case that, well, it wasn't binding until the 2015 court order, which just coincidentally was about 4 months after Kirsten's death. But Your Honor, I submit that contract, that settlement agreement that was entered into on June 23rd, 2009 was a settlement agreement. The parties reached a meeting of the minds and they had a deal. They had a deal. And what's more,
assuming the children did have a beneficial interest at that time, respond to the argument that the mother did not have the authority to unilaterally extinguish that interest because the father should have had a say as well.
Thank you for that question. Yes, Your Honor. If you recall, Kirsten had this power of appointment. She was the sole beneficiary of the trust. She had this power of appointment, and under one of the cases that I cited in my brief, the Peck v. Peck case, Your Honor said, look, even if you're contingent beneficiaries or you are permissible appointees, as the appellee contends, that power of appointment by Kirsten as the power holder can bind both of these permissible beneficiaries, even though the appellee, I contend, they do not. They were not beneficiaries. They were not permissible distributees. They were merely permissible appointees. And so, in any event, I think, Your Honor, if I may, if you read the arguments made by appellant in their opening and reply brief, every single one of their arguments relies on the fact that the two children were beneficiaries. And as the court acknowledged in its questioning of Mr. Hurto during his opening remarks, is these children were not beneficiaries of this trust. These children were not. They were merely permissible appointees. And as we've cited in our briefs, the Florida law says, look, if a
Mr. Bonnet?
Yes, sir.
What are the facts that under the trust, if there had never been an appointment made, they were entitled to receive the remains of the trust per stirpies? What about that? Does that make them a beneficiary?
Only when the class of permissible appointees closes, Your Honor. So the class of permissible appointees closes when Kirsten dies. And at that point, if she's exercised her power of appointment, it would be in her will as a testamentary power of appointment. I submit, Your Honor, that at the time she entered into this settlement agreement with her sisters and brother and mother, that she was still alive and the class of permissible appointees was still open. Now, yes, Your Honor, if she was deceased and she did not exercise her power of appointment, then yes, the two children would be taking equally. But we don't get to that, Your Honor, because at the time she entered into the settlement agreement and agreed, I'm giving you all of the WIBCO stock. I'm giving you all the WIBCO stock because in exchange, I'm getting the Land Associates stock. We have a quid pro quo. I'm going to give you something, you're going to give me something. So Kirsten got something, okay? But at the moment that she entered into that agreement, she was still alive and the class of permissible appointees was still open, not closed. She could have had another child and she could have exercised it all for this other child, or she could have exercised it against one or the other, as Your Honor had pointed out earlier. And so when you don't know who's going to get any of the assets, you don't have an interest in the trust. And that provision of the power of appointment makes sense because if you are a mere permissible appointee, you don't know if you're a beneficiary. You don't know until the class closes. And Your Honor, I submit that although it's true, if she didn't exercise her power of appointment and she died, then it would go to the two children equally. But we don't get there because she agreed to give that up when she entered into the settlement agreement. And when she gave that up, she bound the permissible appointees, her two children. She bound them under Florida law. Now, Your Honor, I know that they're.
Counsel, is it fair to say that your argument rises and falls on whether the settlement agreement was enforceable or not in 2009?
Your Honor, if I may respond to that. I submit that at the moment Kirsten and her sisters and brothers sat down and hashed out their agreement. They entered into a contract and she agreed to give up her interest. She agreed to give up the interest in the trust and the assets in the trust. And I submit that her agreement bound the two children to that. If it were not enforceable, for example, if Pete Deering, the circuit judge in Duval County, said, you know what, I don't think that's permissible under Florida law, I contend that it was still binding on the two children, Kirsten's two children, because she intended to give up the interest in the trust in exchange for what she received in return, the Land Associates interests. And so she gave up something, but she got something in return. So, Your Honor, the answer to your question is that I believe that it does not rise and fall on that. I agree, I have a little bit of more problem because if it wasn't enforceable, there is a problem, but I still believe she bound the two children. Your Honor, I see that I've got about 1 minute left. If I may just address a few other quick things. Much has been said about, in the 40 seconds I have left, much has been said about how there's been a delay because the rulings were not until 2014, 15, and 16 and later, that it wasn't until those orders were entered did this agreement come in effect. And I submit, Your Honor, that that's not the case. Once they sat down and reached their agreement and had a deal, they were bound. And it was at that moment that we test on whether or not the two children had a beneficial interest, and Kirsten bound them and said, no, I'm giving that up in exchange for something else. And I'm out of time. Thank you.
Thank you, counsel.
Thank you. So I want to address initially this question of beneficiary, because if I hear Mr. Bonnet correctly, he sort of wants it two different ways, in each way going in favor of his client. So if it is the case that they were permissible appointees at the time that this contract entered, and Mr. Bonnet did agree that at the moment in 2009, when this proposal was put together, you had two daughters, and as between them, the mother had the power to give all to one, all to the other, or split it some other way. At that moment, she had no opportunity to give it away or not give it to either of them, to completely cut them out. She didn't have that opportunity, and he did not say that was the case. So at the moment that she enters this proposal, if it is the case that it is binding, she is agreeing to give up her rights, which include either the right of appointment and the right to income from this trust. If she gives up the right to appointment, then at that moment, her daughters become default beneficiaries. Something has to happen to the daughters at that moment. And what Mr. Bonnet seems to be saying is, even though this agreement he claims was valid, he seems to argue that because the mother was alive and because the children were alive, going into the future, she could have gotten rid of them. She could have somehow had another child and given all of the benefits to that child. Well, if she gave up the right to appoint back in 2009 and that contract is enforceable, then she doesn't have the right to give away the beneficiary interest to someone else. At that moment, the children have the right. The trust still exists. The trust is never terminated until 2016, after she dies. And certainly after she dies, nobody can do anything about these beneficiaries. So he's trying to have it, I think, both ways by claiming that somehow Kirsten had the right, after this agreement was entered, if it was valid, to cut out her daughters. That could not be the case. They have to be beneficiaries at that moment. The other thing I want to make sure and raise, I know I raised it a little bit before, but at the very least, at the moment that they were talking to each other about what they were going to do in 2009, Mr. Bonnet made it pretty clear. The brothers and sisters were trying to figure out how to take care of themselves. They were figuring out how to divide up the family fortune among themselves so that they could all walk away with some cash in their pocket. At a minimum, there is a question of whether or not Kirsten had the right under the law in that circumstance to make decisions that would affect her children. She had a conflict. At the same time, the trustee, and at the time this decision was made, Wade was the trustee. And as a trustee, he has rights under the law and he has obligations under the law. And one of those obligations is to make sure that he's doing right by any potential beneficiary, whether they're a default beneficiary, call them whatever you want to call them. He had some obligations to them. Did he name a guardian? No. Did the mother name a guardian for these children? No. Did anyone think about the children? That's what this is about. And this is an issue of first impression. There is no case law dealing with the Peck case that Mr. Bonnet refers to. That case did not involve a situation like this where you had brothers and sisters who at the same time have powers under the trust and are the trustee, are making decisions that are going to impact their children.
Counsel, I think your time has expired now. If you want to just briefly conclude for us.
Well, thank you. And again, this is really about these children, and it's about the rights these children had, which were never protected through this entire process. They weren't protected by their uncles. They weren't protected by their aunts. They weren't even protected by their mother, and they weren't protected by a guardian. And I'm asking this court, please, to protect the rights of these children. Thank you very much.
Thank you. Thank you, counsel. For both sides, we appreciate your appearance here today. The court is adjourned.
Thank you.